from the point you are in that chronology to the fall of 1969, where you've been sworn into the Southern District and sworn into the Indiana bar. And obviously you knew at that point you were going to work on the Hill for a time. And I assume you didn't envision yourself as the first woman in the U.S. Attorney's Office.
No, I did not.
But what did the 1969 Sarah Evans think she'd be doing 10 or 12 years down the road from there?
Well, I never had a long-range plan, ever. I mean, I was sort of survival for a while, but in my undergraduate career, I've laughed, my family's laughed harder at the fact that Mother and Dad, who had years of worry about whether I was ever going to finish anything that I started, might think 40 years was okay. So in 1969, there was just a little fomenting of feminism starting. You remember Phyllis Schlafly, you remember the ERA, you remember Gloria Steinem, you remember Bella Abzug. So they were wrestling with these hard ideas, and most of us women were trying to figure out what these voices were speaking about. We knew experientially what they were talking about, but they had words. So in 1969, actually when I got my job with Senator Percy, whom I adore and I'm so grateful to, when I was interviewed by his administrative assistant for a legislative assistant position, when we got to the end of the interview, it was going well enough that we got to salary, and the administrative assistant said, well, we'll set your salary at $11,000. And I happened to know that legislative assistants who were all men, who were getting more than that. And I said, that was bold when I said this, I said, well, okay, fine, except that really I think legislative assistants are being paid more than that. And the administrative assistant says, that's what we can get a woman for, and that's what we're going to pay you. So, I mean, it wasn't subtle. And I said, okay, because that's what we did. That's how we got a foot in the door. Okay. So, there was another legislative assistant, a man, and the whole time we were there, he was here on the pay charts and I was down here. But the government was the only employer that would regularly and reliably take women. The woman who graduated first in our class at American University could not get an interview at a law firm. You've heard these stories. Sandra Day O'Connor tells these stories, Ruth Bader Ginsburg. Many of our own, Virginia Del McCarty, Shirley Scheidler, many of the pioneer women told these same lawyerly hiring stories here in Indiana because that was the culture. So the woman who graduated first in our class, I noticed maybe 5 years ago in a little posted obituary in the Washington paper that she had worked all her life at the Department of Labor because she got a job in government like I did. So government was where women lawyers could get jobs. I did think about taking the bar in Maine. You know, Ken and I didn't have any plans then. And I've always loved Maine. And I thought about that, and I thought, well, that would be a good place. There's no reason why I shouldn't do that. Until I read someplace they had the highest suicide rate in the country per capita. And I also knew they weren't particularly welcoming to outsiders. And women lawyers were in a category of their own as outsiders. So I abandoned that idea. Happily, Ken gave me a reason to come back here.
At the time you became a district judge here, it said the first female district judge in Indiana, by my count, if my history is correct, there were a grand total of 3 female district judges in the country, in the circuit, 2 of whom are seated to my left. And now I tried to do a quick count last week, and I think there's 44 women judges in the circuit, chief judges of the circuit, and 6 of the 7 districts. As one who was there fighting things that that didn't have to be fought the same way as time went on. How do you feel looking back at just the difference in the judiciary today?
Well, it's what I worked for. It was lonesome. Other judges, have told you that. Sandra Day O'Connor said what a relief it was, what a pleasure it was to have Ruth Bader Ginsburg come to the court. Women know that the conversations around the table change when it's all men and one woman, and it becomes all men and two women. That the synergy and the chemistry between the two women change the nature of the discussions. And what one woman says is sort of legitimized by another woman being there. The magic number is supposed to be 3, but I don't know if that's true. I suppose it depends on the size of the gathering. But it was fairly lonesome. There was a lot of attention that I received that I had not actually expected to receive or particularly wanted to have paid to my work as an assistant U.S. attorney and then as a judge. And I knew when I first became an assistant U.S. attorney that people were looking to see, could this woman do this? Could she handle this? And so I had to prepare and then doubly prepare so that I made sure that I knew what I was doing and that I didn't make it harder for other women to come along because I stumbled or I created a bad impression. So I felt that pressure, I felt that attention. But I am very glad. I was glad when Sue Shields came as a magistrate judge. I'm delighted to have Jane and Tanya as my colleagues. I've had wonderful, wonderful law clerks, men and women. They all work together wonderfully. So I am really pleased that finally everybody else knows what I knew to begin with.
Did you ever think of applying for an appellate judgeship?
Well, not for very long. And I mean no disrespect. John Tinder, I mean no disrespect. I don't want to overstate this because it would be misleading if I did, but I was approached a few times to make my name available for the Court of Appeals. And each time I was able to say pretty quickly, thank you. I hear the compliment in the ask, but no thank you. And it's no thank you because I know myself well enough that two things. I have to like what I'm doing in order to get out of bed and do it every day. And a library carol and research and writing all the time as a steady diet were not for me. And I love the trial court. I still love the trial court. Why do you think I'm still doing this? It's because I love the trial court. And it's live theater. It plays out right before you. You cannot script stuff that happens in the court. And you get to watch lawyers who are always entertaining. Sometimes irritating, but always entertaining. Always, really, what they do is admirable. You would be as impressed as I am by the courage that they demonstrate and the skill and just the perseverance and the humanity with their clients. And I get to watch it. And then here are all these jurors who come in and they want to do their duty. You get a little marcher in the group every once in a while who wants to, be the screwdriver in the watchworks. But most of the time, the juries want to do their duty. They want to do what you've asked them to do. They're we have wonderful jurors in southern Indiana. I've always felt like we didn't have to work as hard to convince people that this was important for them to do. And then we have, all of the other ways in which the theater of the trial court plays out. Now, I'll tell you this, but I don't want you to hear it with critical ears. So sometimes I have to convince law clerk candidates that they will be really happy in the district court when they're getting offers from the Court of Appeals, because they have been told that the Court of Appeals is the higher court. It's the more prestigious court. It's where everybody ought to aim, and if you can't get there, you ought to come to the district court. So I know I have to convince law clerk candidates. So I try to do it in a way that will serve my purposes. So, remember, I was a trial lawyer, so I know how to position my arguments. So I will say to a law clerk, depending on how the interview is going and if I feel like I know them well enough, I'll say, let me put it to you this way. If reading about sex is good enough for you, you'll probably be happy at the Court of Appeals. But if you want a little bit more direct life experience, you better come to the trial. And look at all the people who wanted a little bit more direct life experience. They came. So I have been asked, the interesting thing about these asks from my point of view is that I was asked about the DC Circuit, I was asked about the 6th Circuit, and I was asked about the 7th Circuit. But each time I was able to say, in fact, one of the people who called me from Washington to say, would you think about it? I said, I will, thank you, but no, I'm not going to do that. Besides, I have my family here, Ken and the kids, and I love living where we do, an hour south of town. And I'm not going to pack them off to D.C. I'm not going to live without them. What's the fun of that? So this just wasn't going to work out. But the guy who was calling said, well, don't you want to talk to your husband about this? And I said, oh, I will. But I'll tell him what my answer was. So it wasn't anything that I flirted with for very long. I was complimented every time. And I, make light, but I really do appreciate the hard work that the Court of Appeals judges do, sometimes.
Talking about the trial court and the theater, is there any case that comes to mind that you would like to do again, not to improve, we would all like to do them again to improve what we did, but just because it was such a remarkable case?
Well, the remarkable part of the case usually had to do with the people who were involved. The legal issues, I'm intrigued by them, but I'm always drawn to the people. So there was the guy who, this was your case, Bill Daisy. So we got him through a trial. He had a client from over by Brookville Reservoir who lived out way away from anybody. And he had been prosecuted once before by ATF for gun dealing. And he lived in a little shack in the middle of a junkyard. And I knew this, I saw the surveillance pictures. And he was sort of an old geezer. And he'd been prosecuted once, and he didn't learn the lesson. And he had to be prosecuted again for another gun charge. So we went through the whole trial, and we get to the last morning. I was using Judge Dillon's courtroom because mine was out of commission for a while. And as I'm coming around the corridor, ready to handle the last day and get the case to the jury, but the court reporter comes out and says, your defendant's lying on the floor in the courtroom. You remember this, Bill?
Quite well.
Yeah. I said, what? So I went inside and came through the entrance to the courtroom from the chambers, and there he was, stretched out on the floor. No, he was holding his arm. Oh, he said. Bill Daisy is a saint with his defendants. I just want to say that. He is one of the very best. And he's down on his hands and knees talking to this guy in his ear. Hang on now. Come on, Freddie. Hang on. We've called the EMTs. They're coming, Freddie. So, Freddie. So I'm asking the marshal, you got this under control? And he says, oh, yeah. And the marshal was not a bit concerned. So pretty soon, here come the EMTs with their gurney, and they push it in. And the jury is over in their jury room. I'm hoping they're not hearing any of this. And one of the EMTs comes over and sort of looks at the guy and then says, okay, get up here. And I thought, man, he's heartless. Guys on the floor, get up here. So he sort of halfway helped him and got him on the gurney and rolled him out. Well, Ken and I had plans to leave town the next day. I wanted to get this case done. And so I called the marshal, and the marshal says, oh, Judge, it's going to be all right. We took him to Wishart. It's going to be all right. And I said, well, how do you know this? He says, because every day when we'd walk him to the courtroom, he'd say, I can't do 20 years. I can't do 20 years. And the last day before when he was going to have his closing arguments and stuff the next day, so Thursday before Friday. On Thursday, he says to the marshals who have befriended him at this point, he said, wait till you see what happens tomorrow. So that one was pretty funny. And the guy didn't have any trouble. They just got him hydrated, and Bill Daisy did his good EMT service himself, earned his stripes. So that was an interesting one.
So they've had some cases that have been very, very difficult. 4 cases involving overcrowding at a jail.
Yes.
And it's a multi-district litigation, which is always fun.
Yeah.
And of course, a lot of cases involving pharmaceuticals, given the number of pharmaceutical organizations here.
Yeah. The Prozac patent.
Would you tell us what you consider to be a really hard case and why it is?
Yeah. The hard cases are hard usually because it's some version of bad facts, bad law, bad lawyers, bad clients. And when you've got any of those 4 or in any combination, it's going to make it really hard on the court, because we count on the lawyers to help lead us to a position where we can make a decision. And I have said to many lawyers, you have to make it easy. You have to make it possible for a judge to decide for your client. And you don't do that by obscuring the issues. You lead the judge to the answer that you really want. The judge is going to consider everybody's submissions, but you have to bring the judge to the point of being able to decide in your case. And so to do that, you'll know more about it as the lawyer than the judge ever does. So in these days, what makes a hard case hard is the inundation of filings that lawyers are able to make because of computers, and the number of associates that they'll put on a case. It's just one judge sitting on the receiving end of that stuff you're sending over. And for us to figure out where the needle in the haystack is very hard. If the lawyer has not done the lawyer's work, somebody's got to do the lawyer's work. And it falls on the judge to go back and read that deposition to see if it really said that. The MDL case was the Ford Firestone case, and I would not be able to sit up here and tell you anything cogent about life or anything else if it hadn't been for Debbie Lynch and Sue Shields, who absolutely took that bull by the horns and helped me and all of us wrestle that one to the ground. We had lawyers from all around the world, not just the United States. We had language issues. We had lots of litigants, very sad facts, because these tires fell off the cars and caused bad accidents. Whole families were wiped out when the tires went off the car because of the way in which compromises had been made by Ford in the way in which they put the amount of air in the tires. So it was an inflation sort of issue in the tire. But there were good defenses, and there were really good lawyers on both sides, and over 600 individual cases that we had to resolve. I do remember the first day. I'll see if Debbie Lynch remembers this. I wanted Sue Shields to sit at the bench with me because the two of us were going to have to work in tandem on this. And she was, just such a dear friend besides a treasured colleague. And so I said, we're going to put 2 chairs up there. And when I came into the courtroom, it was like a convention of Brooks Brothers suits. The courtroom was absolutely filled to standing room only, with people there representing, various clients and various law firms and so forth. So when we got to the end of it, we'd set schedules. We tried to explain the rules of the road, how we were going to approach the problems and the processing of the case. And so it took about an hour and a half. And when we got to the end of it, I said to Sue, I have one last thing to say. I'm going to say to the lawyers. She didn't know what I was going to say. And I said, so, okay, I just have one more thing to say. I said, you know the Betty Davis line? When you have something you want to get done, give it to a couple of old broads. We're your couple of old broads. So at least we broke the ice with all those lawyers that day, and they knew that we were going to be working very closely together. The jail conditions cases were tough. The Marion County Jail, the Delaware County Jail. The Delaware County Jail was a problem that was wrapped in layers and layers of local politics. And the Marion County Jail was wrapped in layers and layers of governmental issues, no money, no place to put prisoners. So they were very difficult, challenging governmental problems. But in all those respects, the court did what the court's required to do, and that is keep pushing, ruling until a decision can be made. When I say something like that about how long some of these cases last, I remember the guy that wrote to me, and he was talking about how protracted his case had been, not his word, mine, about protracted. He was in prison and he was pretty mad. And he was talking about his lawyer not paying attention to him, and it was just going on and on. And he says, I'm at my wit's end. And I have to say, on those cases, we reached the point of being at our wit's end.
I would add on that Firestone case, I think you probably know this, but others don't, that was a case that had no district. That was central to major to the case because it was fully national. And the panel just tried to figure out of all the judges in the country, who could handle this well. And so it's a great compliment to you that they paid them.
I didn't know that.
Yeah.
I thought I did something wrong.
Well, that's their way of thanking people.
Yeah.
You're very well known among the judges, at least, all across the country for your work with the Federal Judges Association. Could you tell us a little bit about that and why it means so much to you?
Well, I served 2 years as the president of the Federal Judges Association. I got started in the Federal Judges Association just as a board member, but they were putting together a newsletter. And you know how it is when you volunteer for a newsletter. It puts you right in the middle of the puddle. And that sort of was what allowed me to climb the ladder and hold other offices, vice president and so forth, but it was starting out with that newsletter. And this is an organization of about 1,000 Article III judges from across all the states and all the districts. And at that time, our primary interest was the inequity of judicial salaries, which were very, very out of line with the law firms and with the academy and everybody else. So we were spending a lot of time working on judicial salary issues. And my work on the Hill was an asset in those problems and how to manage trying to get something done. As it turned out, we never did get legislation because we just could not penetrate the fortress. But we did litigate. And it turned out to be really interesting litigation. We filed a case in the Court of Claims, and then it went up to the Federal Circuit. It lingered a long time at the doorstep of the Supreme Court, and they decided not to take it because we'd gotten 2 favorable rulings. And it had to do with the no diminution in pay. And that was the constitutional problem. But the other part that was really quite creative of the lawyers who were helping us was they found a statutory error that had been made with the way our pay was being calculated in terms of COLAs. And that was just beautiful, dogged staff work by good lawyers. So it turns out that that litigation that we brought, they had a sample group of plaintiffs, and my name was first. I married into the BA of Barker, so it was always referred to as the Barker litigation. So if you go back and you Google Barker litigation, that'll be that case. You know, we're supposed to end at 9, and I have a few other remarks that I want to make that won't take too long, but I think we were supposed to ask if there were any questions that anybody wanted to ask from the audience. The one question that you told me that you were going to ask that we didn't get to because we had a lot of questions, I'll put out there because I came up with an answer. So I need a question to give you my answer. The question was yours, Bob, and it was about when this life is over, how would you like to be remembered? So I did come up with 3 things, but I hope my life's not over for quite a while. Show applause. In the record, show applause.
Sustained applause.
Yeah. So I did come up with my 3 things. I want to read them to you because I did this afternoon, and I thought, well, maybe that'll work. I took my work seriously, but not myself. I'd like to be remembered for that. I held the door open for other women who came after me and who came alongside me. And, let's see if I can say this. My family always knew they mattered most to me. Those are the 3 things. Bill, do you want me to give my little finale?
You're ready now.
Okay. You wouldn't say no, would you? Well, the hour is late, and the time to conclude this wonderful program is obviously drawing nigh. You can hear in my voice that it's time to let it draw nigh. But I want you to give me just a few more minutes to offer a few reflections in bringing the evening to a close. This evening was structured as a conversation intended to lead to the creation of an oral history, which can be retained as part of our court archives. Somehow it was determined that my judicial story deserved to become a pocket supplement, you might say, for inclusion as a part of the stellar history that already exists of our Southern Judicial District. It's a history that includes such luminaries as Judges Balzell and Steckler, Holder and Dillon, Noland, Brooks, McKinney, Tender, Hamilton. And so I'm honored, beyond telling, to follow in their footsteps. But as fun as and fulsome as this evening's conversation has been, the reason I wanted to deliver these few final remarks is because I think the record might be incomplete without some sort of concluding observation, some reflections. So I have 3 reflections to add to the record of our proceeding. First, allow me to say again and out loud what I've said to myself every day of my 40-year judicial tenure, and that is how privileged I have been to have the opportunity to devote almost all my professional life to the performance of the worthy work of judging. For this opportunity, my thanks extend back to many people. Of course, my wonderful parents, grandparents, I can do this, grandparents, my siblings and my spouse and our children, to many educators, to clergy, to many, many extraordinary, generous, and supportive friends, many of whom are here tonight, and my beloved colleagues, many of whom are here tonight. And specifically, of course, to Senator Lugar and to President Reagan, who chose me to fill the vacancy created by the untimely death of Judge Holder, and thereby allowed me to become the first woman to occupy a seat on the Indiana's Federal District Court bench. It was at that time a gutsy and courageous act of political leadership, which I hope neither of them ever grew to regret. In accepting the appointment, I was empowered to do work that has brought me face to face with some of the most difficult and intractable challenges facing our country and our fellow citizens. The work meant ensuring each person's entitlement to fair treatment and personal respect and dignity and equal opportunity under the law. And it meant knowing that the rule of law is our only hope for preserving and enhancing our democracy. It meant knowing that the rule of law is absolutely foundational. The work of being a judge has required my best efforts, my sustained attention, and on many days, virtually all my energy. But the payback has been lavish. It has given me an extended reach into so many lives, as well as into the life of our community and our state. And it has also allowed me to serve alongside truly gifted colleagues and associates, both on the bench and in the bar. People I came to admire for their integrity and their kindness and their deep wisdom. They inspired me and made me not just a better judge, but a better human being. It would have been gift enough just to be a better judge, but I got a bonus because they helped me be a better human being as well. So more than anything, I am grateful, so grateful. The second thing I want to mention is that I want to speak a public word of reassurance about the courts and our system of justice. In short, about our judicial branch of government, both about its continued capacity as well as its commitment to perform its constitutional function. Our courts, like other governmental branches, have been under enormous strain in recent years. We're flooded with case filings, and the issues entrusted to judges for decision-making have been increasingly intractable. In addition to the ordinary disputes that find their ways onto court dockets, the contract and employment discrimination cases, the property and tort claims, the garden variety criminal prosecutions, think what it means now to also have lawsuits which involve climate change, AI, satellite technology, and social media, including the dark web, alternative currencies, international relations, and the prosecutions of our highest government officials for the ways in which they conducted their lives and their official duties. It's a really big ask to require an individual judge, when the scope of the controversy is both novel and enormous, to do what a judge must always do, namely to interpret the law fairly and wisely, and to enforce effectively and efficiently the promises set forth in our Constitution and our statutes. No individual judge gets it right every time, of course, and no system of justice is infallible or perfect. And there is, God knows, plenty of room for necessary improvements within the judicial processes. But what I want you to know and draw comfort from is this. Within the structure of the legal system and the design of the courts, there exists the capacity to provide order